Thank you very much, Stephen. Our next talk, and this is the last one before our lunch break, is by Miriam Kelly, and it is on real estate remedies. Miriam Kelly was the head of the real estate section of the Canadian Bar, the Ontario branch, for some time, and has been responsible for many of the excellent educational programs that section has given. Miriam is now on her own, having been with a large firm in the past, and is specializing in, or is practicing in a general area, but with a great emphasis on real estate. Miriam, as probably most of you know, has been extremely active in the Canadian Bar in the organizational end, as well as in the substantive area of real estate. She has given many lectures in this area and has a reputation for one of the very best lecturers on these practical remedies. Miriam Kelly.
Thank you, Mr. Chairman. I'm a little alarmed to be surrounded by all the academics and the barristers, since the only association I have with the theory is to see what I can extract in the way of practice. However, I was told to give a specific performance, and though I tried rescission, I was told it might be considered repudiation, and that there might be a mandatory injunction, and that the breach, the damages for any breach might sound in tort, so here I am. It's a little, in trying to canvass 20 years of remedies in this area, it's a little like Steve Podborski on the way downhill. You have to pass a lot of landmarks in a very short while. Also, I know it's 10 minutes to lunch and you might be thirsty. Anyway, in real estate, restricted to real estate and restricted to new developments, we are considering remedies. If we go to Oxford, Oxford tells us that a remedy is a cure for any disease or any evil, and that it's a healing medicine or a treatment, and it's the righting of a wrong. And since the doctors talk about internal and external medicine, I guess we can take the analogy. Our internal remedies, that's our common law, that's been evolving and continues to evolve. Our statute law, our external remedies, well, those are the remedies that the legislators deem necessary to cure some evil, and as far as we can figure out, there are an awful lot of things that they think are evil. What was new in 1970 was 6 volumes of the Revised Statutes of Ontario, and they've since added about 49 inches. So I guess what we can say is that while we are trying to follow our case law, we are certainly buried under our statutes. 2 professors from the University of Western Ontario produced a little booklet called Losing Ground, and it identifies at least 200 statutes affecting our practice in land law. And our favorite, of course, the Planning Act. Every time we think of a remedy for the Planning Act, the legislators remedy the remedy. And we have a variety of newer statutes. Of course, there's been great development in the law of landlord and tenant, which we haven't time to deal with today. But we do have the Environmental Acts, the Family Acts, the Succession Acts. We have amendments to our basic statutes, the Registry Act and Land Titles Act. And we also have coming the Children's Law Reform Act and the Limitations Act, both of which I expect will affect us in our practice. However, one of the most interesting developments in the question of land law is that mentioned in the Supreme Court in the Highway Properties and Kelly Douglas case, where the Supreme Court indicated that it was time that we stop thinking of land law as so special and consider it more in the nature of contract law. The first contract that one meets in dealing with land, of course, is the contract with the real estate broker, usually. And that one, I am happy to report, contains nothing new and startling. They're the same problems and somewhat the same remedies. However, in another area, condominium, we do have, first of all, since the 1960 lectures, we have a whole new idea. The idea of condominium itself is new. And we've recently had the amendment in the Condominium Act 1978. There are three, if you could call them basic or big remedies that I would just like to identify briefly. First of all, in that new statute, the action against and the action by the corporation and the liability of the owners of a condominium unit after June 1, 1979. And that is, it depends whether you're a winner or a loser, whether that's a nice new remedy or not. The estoppel certificate, that document which a purchaser wants to see, indicating that there is no arrears in the payments for common expenses. The estoppel certificate, which one is obliged to give by the statute, doesn't provide an or else just says that there are no arrears. It doesn't tell you what else is the problem with your particular condominium. The third item I'd like to mention in connection with condominium, it's a kind of a, you could call it a new remedy, and that is the document known as the disclosure statement. When a declarant, that's the person who invents the condominium, or a proposed declarant is selling units, that declarant or proposed declarant must produce a document which includes the structure, as it were, of the condominium corporation, the declaration, the description, the bylaws, and so on. That particular document is called a disclosure statement, and it must be produced to a purchaser. And the purchaser has 10 days, the cooling off period, to decide whether he wants in or out. And if there is a major change in the disclosure statement between the time the purchaser signs his agreement and the time he takes his transfer, he has another 10 days from the presentation of the amended disclosure statement, another cooling off period. Another new remedy for our purchaser is found in the new Home Warranties Plan Act of 1976. This provides protection to a purchaser of a new unoccupied or previously not occupied home. All these terms are defined in the statute, and they deal with poor workmanship largely directed to structural defects. And every vendor, as defined in the Act, warrants to the owner that the home is constructed in a workmanlike manner, that it's free from defects in material, fit for habitation, and built in accordance with the Ontario Building Code, and that it is free of major structural defects. Now, what happens in practice is the purchaser arranges a little inspection before taking possession, and the vendor delivers a certificate with respect to the items mentioned, and the warranties spelled out in the certificate take effect from the date in the certificate, and we're thinking generally in terms of a year. Now, what the Act does not protect is from work that hasn't been done, just work that has been badly done. Some purchasers are of the opinion that by getting the certificate, you can force a builder to do certain work. You can force them to do it properly if it has been started. Now, the Workman's and the Materialman's Remedy, that's the Mechanics' Lien Act, has some new developments. The reason I will not go into them today, apart from time, is that the legislature has given us a draft Construction Lien Act. And I know it's unwise to mention proposals in draft acts before they have been passed by the legislature, but you just might like to know how this particular legislature is thinking in terms of the remedy for the workman and the materialman. First of all, they're thinking of a holdback of 10%, a lien period of 60 days, the substantial performance, in quotes, applying only to the main or the principal contractor, and in contracts over a certain amount, a trust fund, a trust account held jointly by the owner and the contractor, and the lien would then be on that account. There will be, if the legislation is ever passed, no waiver of the rights, and there will be a special right for developers who have installed services for a municipality and have difficulty getting their monies out of the municipality. Now, to get to what we generally think of in terms of land law, buying and selling and mortgaging and so on, we, under remedies, if we're going to take the extension of that medical analogy, we can also think of preventive law as well as preventive medicine. And one of the things we think of is how do we prevent the kind of lawsuit that results in what we're going to discuss later. A vendor can protect himself in a variety of ways. First of all, if he is entirely unable, if there's a true condition precedent in his agreement and it cannot be fulfilled, then there is, of course, rescission. Next item along the way usually concerns requisitions. There is recent case law with respect to requisitions, and the distinction that we have to watch is the particular requisition a matter of title or conveyance, and if it is not a matter of title or conveyance, it must be raised within the time permitted for requisitions, so that your vendor has a remedy if the requisition was made late. Some of the cases recently, an easement was determined that it must be made within the time limited, and that's the McFadden and Pye case in the Ontario High Court. If a requisition concerns a work order, it must be made within the time. That's Jackson and Nicholson, a 1980 case, also in the Ontario High Court. And so that's the last of the two that I want to mention. The next thing that I want to come to is the question raised in the cases of Fong and Weinper and the Garfried case, and that is that the vendor must be ready, willing, and able, and that includes he must have his discharges of mortgages that are not being assumed, he must have them off the title or must have the discharge available at closing. Now, sometimes the vendor is aware of a problem on the title, and what he does to prevent a loss of a sale in that case is he makes sure that the purchaser is aware. Customarily, that would be in the agreement of purchase and sale or by some document that precedes it, of which he can establish that the purchaser has notice. Now, sometimes there is a defect of which the vendor is not aware. At least he isn't aware how serious it is. And in a particular case, there was a defect, and the property, in fact, collapsed, and the court awarded the plaintiff damages in the case of McGrath and McLean. That's the Ontario Court of Appeal. And as Stephen Wadhams has mentioned in the Rhymes case, all our conditions precedent must be fulfilled. Now, if we go past that point and we are getting close to closing and we face a breach, what is the vendor to do? Well, as you know, breaches are anticipatory or at the time of closing. An anticipatory breach, the vendor can accept the purchaser's clear indication that he's not going to close, and he can retain the deposit. If he does this, of course, he has then tied his hands with respect to his further remedies. He doesn't have any further remedies of specific performance and damages for the breach of contract. Now, if he does not retain the deposit, or if he's prepared to have the deposit accounted for, he may sue for damages for breach of the contract. And a recent case in our courts, the Woodford Estates case. However, he must watch, if it's an anticipatory situation, not to ask for specific performance at that time. He will have to wait until the time of closing comes, or at least ask for specific performance at the time of closing. If the vendor chooses not to accept the breach and waits until closing, he must, as we mentioned, be ready, willing, and able to close and to complete the contract on its terms. And if the purchaser then doesn't complete, the vendor can sue for specific performance and for damages for breach of contract, though by judgment he must elect. Now, in a fairly recent case, the vendor agreed to sell Blackacre to A, and he thought that deal had fallen through, so he agreed to sell Blackacre to B. And of course, that leaves one purchaser out of luck. One purchaser doesn't get the property, so of course he sued. And in this particular case, which is the AVG Management Science case and Barwell, the court said that the vendor had put it out of his own hands to complete his contract. Now, it may be that it's through the fault of the purchaser that the contract can't be completed, and in that case, the vendor can say, well, in fact, there is a contract right up until the court date, and there is a particularly interesting case in which damages would be allowed at the date of what was turned out to be what was an original order for specific performance. And the court ordered that there would be a discharge of that order for specific performance because there was a contract, Then it terminated the contract and gave damages for the breach. Now, sometimes a purchaser puts himself in a place where he is going to have difficulty, and in drafting his agreement, he hasn't protected himself from that position. And if the vendor is still able to give good title, the court will award specific performance. And we have the case of Victoria Wood Development and Andre in the Ontario Court of Appeal in 1979. Now, sometimes a contract is frustrated through no fault of either party, such as legislation being passed which wasn't contemplated by either of them, and the court then endeavors to put the parties back as far as they can. And in the case of Capital Quality Homes and Colwyn Construction, the Ontario Court of Appeal determined that the purchaser had the deposit back. In watching which way you go in pursuing your remedies, we meet the case of 100 Main Street and W.B. Sullivan Construction Limited, a Court of Appeal case in '78, where the vendor sued for damages only. And the court said since he hadn't asked for specific performance, he wouldn't get it. And he got contract damages for the difference between the contract price and the value at the date of the supposed completion or the date of acceptance of the anticipatory breach. Now, we've heard earlier that the courts have proceeded some distance from Bain and Fothergill and Hadley and Baxendale on the question of damages. Bain and Fothergill, you will recall, is a case in the last century in England where a vendor, through no fault of his own, had a title that he couldn't sell. And the court said in that case that the purchaser was entitled to his deposit back with interest and his costs of investigating the title, and that was it. And the Hadley and Baxendale damages, following Hadley and Baxendale, damages would have been assessed at the time of the breach. Now, as you know, things have changed a little bit. In the Woodford case that we mentioned before, the court awarded damages, but the land had decreased in value, and so the court decided the vendor got damages based on the difference in the value of the land at the time of the contract and the value of the land at the date of the breach, not the trial, and gave the purchaser credit for the amount of the deposit. Now, if we get close to closing and the vendor indicates that he's not going to complete, the purchaser has the same option. He can accept the anticipatory breach and demand his deposit and accept its return with interest from the date of demand and consider the matter closed. Again, if the purchaser takes this route, he has cut himself off from any further remedies such as specific performance and damages for breach of contract. Now, can a purchaser do anything to prevent the loss of a purchase? Well, the other side of the coin, of course, he can get all his requisitions in on time, and he can remain ready, willing, and able to complete at the time scheduled for closing. And sometimes it may be that the reason that the vendor is unable to complete, it's the vendor's fault. The vendor didn't do something that the vendor was supposed to do, didn't obtain something that he was supposed to obtain, or didn't fulfill some condition that was within his power to do. And we have a case in the Supreme Court of Canada, Dynamic Transport Limited and OK Detailing in 1978. And the court in that kind of case orders the vendor to take the steps to do whatever the missing something is and then complete. Now, there was a case in which the vendor was to have title by the date of closing, and it was within his power, and he didn't have title at the time of closing, so the purchaser elected to keep the contract in force and did get specific performance, and that's the case of Macaulay and McVeigh, a 1980 case, singular. Now, we've heard mention of our friend Roth and Tyler, in which the damages for failure to complete were awarded as at the date of trial. And as was mentioned, this was a couple who had spent all their money to try and buy this particular property. Now, the case in Canada, Metro Trust and Pressure Concrete, in the Ontario Court of Appeal, the purchaser was awarded, instead of specific performance, which couldn't be enforced. Equity doesn't act if it's going to be useless. And in that particular case, specific performance was not available, but the purchaser did get damages as at the date of judgment. And the Rhymes case, we mentioned that the court awarded damages for breach of the contract assessed as at the date of the trial. Now, in the AVG management case that we mentioned a minute ago, the Supreme Court determined that damages were not limited to Bain and Fothergill damages, and particularly since that particular vendor had put it out of his hands to complete, and so the damages were awarded, measured the difference between the contract price and the value of the land at the date of the breach. And the court commented in that case, I think it's only obiter, but it shows you how the court is thinking, that if it had been necessary to decide the question, it would have determined that the rule in Bain and Fothergill ought no longer to be followed, at least in provinces where there was a Torrens system, and perhaps also in the provinces such as ours having a registry system. There is always, of course, when one is dealing with litigation relative to land, the admonition that if it is a proper case, you make sure you put your lis pendens on to protect your rights. Now, to turn quickly to the question of mortgagor and mortgagee, is there anything new in the remedies available to a mortgagee? Well, mortgagee always has, according to the piece of paper, the mortgage, and according to what appears to be his rights in the Mortgages Act, he's got lots of remedies. He's got his action for possession, he's got his action on the covenant, he's got his sale under the power of sale in the mortgage, he's got foreclosure, he's got judicial sale under the watchful eye of the court, and it should be home free for a mortgagee. However, those of you who've acted for mortgagees know that on paper it looks good, just try and enforce the remedies and it's a mortgagor's world. The case of Walden Pape in the Ontario Divisional Court, a mortgagee had some trouble on the covenant. The mortgagor had sold the equity of redemption to a subsequent purchaser by a deed which included a covenant to assume. Thereafter, the subsequent purchaser was given an extension. And the court said, well, there seems to be a triable issue here, and did issue an injunction. The triable issue was raised by the argument that the original mortgagor had become a surety, and that on the granting of the extension agreement, the surety was discharged. Now, Section 21 of the Mortgages Act, and incidentally, there haven't been very many amendments to the Mortgages Act other than Section 22, which we're going to mention very shortly. 21 is the section which gives a measure of relief to the mortgagor. He can put the mortgage in good standing and carry on, as long as no action has started to enforce the mortgagee's right. And by Section 22, he can have some relief after the action has started. The Section 21 remedy is limited if we've had a completed agreement of purchase and sale, or even a successful bid in an auction. And that is so even if, and you'll see the real estate agents putting this in the agreement of purchase and sale, if it says subject to the rights of the mortgagor to redeem, doesn't matter. If the agreement is signed, that's it. That particular game is over. Now, the mortgagee is limited. He can't do anything once he has commenced a proceeding by the sale by notice under the power of sale. He can't do anything other than, I think, perhaps keep alive for the 35 days. But the courts have indicated that if any action, any move is made by the mortgagee, he has to start all over again. However, there was a mortgagor that thought, well, we can extend this and make this one sort of dribble along. And in Double D Developments Limited in Green, a 1980 case in the High Court, Mr. Justice Eberle said, well, now you can't go making demands for particulars and all that kind of thing when you're not giving any indication that you really are going to put the mortgage in good standing. So you can't stop the mortgagee proceeding like that. Now, one of the first things that, of course, a mortgagee will want to do is say which remedy, and it is wise to get the order in your mind of the remedies that you propose to take, because it may be that you cut yourself off by going one way rather than another. And this happened in an action commenced by a specially endorsed writ for foreclosure. The mortgagor didn't appear, he didn't give a notice desiring an opportunity to redeem, and the mortgagee proceeded and got judgment nisi for foreclosure. There was a reference directed to the master with respect to the encumbrances, and there the matter stayed for a while. That particular judgment, by the way, there had been the plan to include this clause, but the clause providing for the reconveyance to the mortgagor upon payment to the mortgagee of all monies due had been deleted. Anyway, the mortgagee did not take out the final judgment, and said, well, I think I'll go by notice of sale under the power of sale, and did. And the court said, oh, wait a second, you've already got something going in the court here, and you can't do both at once. So the power of sale and the mortgage was suspended until a foreclosure action was completed. And in another case, a mortgagee had two securities, really. He had a loan, and then he had collateral security in the mortgage. And the mortgagee proceeded by foreclosure and sold at a deficiency and tried to sue for the deficiency. And the court said, no, can't do it that way. You've placed it out of your hands to restore the property. You can't restore the property anymore. You've taken the land instead of the debt, and you can't sue for the deficiency. And those two cases, Petranic and Dale, 1976 in the Supreme Court of Canada, and Bank of Nova Scotia and Dorval in the Ontario Court of Appeal in 1980. So you might say, well, why don't we just go and get judgment in full, and then we'll have that handy, and then we'll go and sell and be able to proceed for the deficiency. And that's all right, that's a good idea, just that your mortgagor may delay you in trying to defend the action, and the swiftness of the sale under the power of sale will then be lost. The power of sale, we have some recent coloration to the remedies. Used to be that foreclosure was the remedy people sought, because then you could sell the property and that was it. Then it seemed that was a little lengthy because you could be motioned to death on a foreclosure. So it was decided, let's go under the notice of sale, at least the sale under the power of sale in the mortgage. And the recent cases, which we're just about to discuss, show you why now people are thinking maybe the best idea of it all is go under the judicial sale and let the court monitor every step, and then there's no attack. One of the things that you wonder about is the question of priorities, liens, and so on. And there are a variety of cases dealing with Section 35, which I will give you in the paper that is published. I'd like to dwell for a moment on the hazards in the notice. The courts have had several comments on notice: who can sign it, who can give it, where does it have to go, and so on. The most interesting case that started all this chain, I think, is the Hyde and Besserer case in '72. And there were a list of people who should have been given notice, and all but one were given proper notice, and the court held, since one of them hadn't been given notice, the notice itself was improper, and the rest of the proceedings fell. Then we've had cases dealing with the last known place of address. It says that you must give it to the last known place of address, and what is that? Well, in one particular case, the mortgagee used the address of the property, and he also tacked a copy of the notice up on the property. And the court said that wasn't good enough. In fact, you knew that mortgagor was not there. You corresponded with the mortgagor somewhere else, and so you didn't give proper notice. It could be that the notice itself is defective. It might refer to the wrong sections and parts of the Mortgages Act. And there's a '77 case, Recomrie Lumber, in which that was the case. While we know a solicitor may sign a notice under power of sale as an agent, he must identify himself as the solicitor to the mortgagee, and that was an Ontario High Court case in '79, Cecia and Reed. It also warns us, at least another case warns us, that because of a mortgage being paid off, one mortgage had moved up. So what was described as third and fourth mortgages were actually second and third mortgages, and both claims were joined in the same notice, and the court held the notice was not good. A very obvious one, the redemption period was too short. Of course, the notice would be bad. And the Court of Appeal has stated that Section 32 is complied with when the requisite notice is sent by registered mail to the person to whom it is addressed at his usual or last known place of address, whether or not it is ever received by the mortgagor. Don't like that one too much. The court did decide in the Imbrook case that the address which was on the back of the document was satisfactory, because even though the parties were aware that there had been a change in address, in fact, that was the address on the back of the document. And Mr. Justice Eberly, I believe it was, has commented on whether you have to read the documents in the registry office in order to ascertain what's happened to the title and whether there's been an assignment with a reassignment and addresses have changed and so on. And his comment was that you don't have to examine the documents. I wouldn't lean too heavily on that because it's rather difficult to explain how you could have had the document in your hand to find the address and not been able to find out some of the other details in the document. Sometimes, if it's a minor irregularity, you can lean on Section 27 of the Interpretation Act. Madam Justice Wilson in Rebotiak and Collison indicated that the Interpretation Act was of help if the particular deficiency in the notice was minor, if it was not calculated to mislead, and a fresh notice would not be necessary. However, she did comment as well that there might be a fresh notice necessary if the accounts changed. The Alloy case in 1980, Mr. Justice Oster in the High Court said, we can't have changing notices every time the account changes because the account changes every day. If the account is accurate on the day the notice is given, then it will be satisfactory. The Botiuk case, actually they considered there'd been such negotiation that in fact it was a whole new deal, and that's why a new notice would have been required. Now the mortgagor can still protect himself. He can still defend the action. He can still pay up if he can find the money. He can still pay in his $100, and that's his security for costs, and he will get relief as soon as he pays the amount in default. He can file his notice of DOR, desiring an opportunity to redeem, his notice DOS, an opportunity to sell, and he can obtain the injunction, as we mentioned in Walden Pape, and challenge the mortgagee's right to obtain any deficiencies. But the mortgagor has to keep his hands clean too. We have a 1980 case in the Ontario High Court in which a mortgagor had defaulted, the mortgagee proceeded, and the mortgagor said, wait a second, we need an injunction here. And so the court said, yes, you can have an injunction, but on terms. Mortgagor defaulted again, having failed to meet the terms, and the court said, no, this is a matter for our discretion. The balance of convenience is in favor of the mortgagee, and you can't have any more. Now, the last topic which comes to mind, and it's a topic that's dear to our heart, is the remedy in land transactions of a dissatisfied or a disserved client against the solicitor who has looked after that client. I won't scare you by all this. I'll just tell you that the standard of care is the standard, and I'll read from the case of Brenner and Gregory. The obligation of a solicitor to exercise due care in protecting the interests of a client who is a purchaser in a real estate transaction will have been discharged if he has acted in accordance with the general and approved practice followed by solicitors, unless such practice is inconsistent with prudent precautions against a known risk. Solicitors have been found negligent for failing to make inquiries, say with respect to zoning, for failing to report on easements, for failing to disclose when they were acting on both sides, something that one side told them that they should have told the other. And the Supreme Court of Canada in that Macaulay case that I mentioned came down very hard against solicitors who act in both capacities. And should a solicitor be so unfortunate as to be sued, the next wonder is, what remedy? Will it be tort or contract? And the courts seem to be leaning against the joint, but they are, unfortunately, there is sort of like the hint in the wind that the remedy against the solicitor may one day be found in tort. At the moment, it appears to be found in contract. We have two fairly recent cases. We have the case that is unreported just yet of Cumberland Capital and Vine. Mr. Justice Robbins says, I can find no basis for distinction between this case and the earlier cases referred to by the applicant, including in particular the case of Schwebel and Telekes, in which case it was decided that the damage rose from the breach of duty and sounded in contract, and damages would be from, at least would based on contract damages. However, just to spoil our afternoon, we can observe that if the West ever separates, we will be spared the decision of their British Columbia Supreme Court in Jackson Davis, a 1980 case, in which the court found a solicitor who had acted for multiple clients on the same transaction had shown a lack of candor equivalent to deceit, that the tort of deceit was analogous to equitable claims for breach of fiduciary duty, and that damages were not to be limited by any test of reasonable foreseeability as would be done in a claim for negligence or breach of contract. In other words, unlimited damages as long as they flowed from the breach. Fortunately, I think Page and Dick is still law, and we still are a bit saved. And I think by now, the chairman will want us to leave for lunch. And besides, I want to see if Steve Podborski made it. Thank you.